Go.
Hello, and welcome to the Action Alliance Continuing Advocacy Training Module on Confidentiality, Privilege, and Mandated Reporting. This training is intended for advocates, law enforcement, and any other professionals who work with survivors of sexual and domestic violence in Virginia. This is being recorded in March of 2021. So the information shared in this training is accurate as of March of 2021, and we will be updating this training periodically. My name is Caitlin Bradley. My pronouns are she, her. I'm the legal director for the Project for the Empowerment of Survivors. And I want to give special thanks to our legal intern, Red Warden. Her pronouns are she, her, and she's at the Richmond School of Law, class of 2022, for her help with this training. So getting right into it, the purpose of this training really is to strengthen advocates' understanding of the privacy principles that protect survivors. It's also to provide a framework or a common understanding for how these principles operate in court systems, and also to prepare advocates for subpoenas or hostile requests for information that is otherwise confidential. So getting right into it, we're going to start with the topic of confidentiality. This is a word that we use a lot in our field. It's important to understand really what it is. Confidentiality at the core is a broad duty to a client. So confidentiality is an obligation that is placed on the shoulders of a professional. It's not a protection or a shield for the professional, it's a protection for the client. Similarly, when we ask the question, who does this belong to? The person that is protected by it. So this would be the survivor or the client. So in other words, confidentiality isn't it's not a tool that a professional gets to use or wave around. It really belongs to the client, and we'll get into that a little bit more. The client can waive this as he or she decides, but it really is meant to protect the client, and it is meant to be controlled by the client. How does it apply to advocates? So in Virginia, we have a statute that does create a duty for individuals providing services to victims of domestic violence, dating violence, sexual assault, stalking, etc. So this statute is the code in Virginia that creates an obligation or a duty for advocates in the state to keep information confidential when working with survivors of sexual and domestic violence. There's also federal laws that create those obligations, and we'll get into that. But in Virginia, this is our specific code reference that creates that duty for advocates in Virginia. And one note that I'll make as you're going through this training, hopefully you have the materials with you at home and you can follow along. I would just bookmark these statutes because the statutes are subject to change. But these references, these code references can be useful in your work. So if you see a statutory reference here, I would just mark that for your records to revisit later. But in Virginia, the duty of confidentiality does apply to all advocates working with victims. Confidentiality is not a shield, and we'll get into that a little bit more when we talk about privilege, which is a shield. So we're going to distinguish confidentiality from privilege. But confidentiality is not a shield against court order disclosure. Like I said before, it is a duty that a professional has to their clients. So laws that establish duties of confidentiality generally include exceptions for court orders, and we'll talk a little bit more about that later. But in general, a duty of confidentiality does not operate as a shield against disclosure in court proceedings. In general, courts generally prefer a principle of broad disclosure of information. So in litigation, generally speaking, courts really believe in a principle that the more information the court has, the better. So in general, there's a background principle operating in court systems that says, we need the most information we can get from all the sources to make a fair and just decision. The limiting principle for that concept that we prefer broad disclosure is a concept called privilege. So privilege is a shield. Privilege is a legal rule that protects certain records and communications from disclosure in court. Privilege is based on court rules and statutory rules of evidence. So it's important to understand that the source of privilege is statutory in nature. So that means that it varies from state to state, and it varies between state and federal court. So it's possible that advocates may, have a career in one state, let's say North Carolina, and then they move to Virginia. The rules are going to vary between those two jurisdictions. It's also possible that an advocate in Virginia could be subpoenaed to appear in a state court and also a federal court. And again, the difference between those two court systems means that there's going to be two different sets of rules governing what privilege is and isn't. This training is really going to focus on Virginia courts and the Virginia rules of evidence, because in Virginia, advocates are most likely to be subpoenaed to a state court level for a domestic violence or criminal matter or family law matter. So we're going to focus on the Virginia rules. So what is privileged? Communications and records between individuals in certain types of relationships. And again, those relationships are defined by rules and statutes, and I'm going to go over what all those are in a moment. But in general, when we look at what is privileged, it's communications and records between individuals. And going back to what we discussed before, what is privileged and what that means is that those records and communications are protected from disclosure in court, which again is not the same thing as confidentiality, but is similar and related. So who holds the keys to privilege? So the duty of confidentiality we mentioned belongs to the client. Privilege is a little different. The protected person does hold the keys to privilege and can waive privilege, but judges also hold the keys to privilege, and judges can compel disclosure even when something is otherwise privileged. So judges have the authority to decide when to consider something privileged or when to compel disclosure. So it's important to understand that no matter what, a judge is ultimately the authority on what will be disclosed or not disclosed in their courtroom. So what types of privilege exist in Virginia? We have a couple. We've got attorney-client privilege, which many people have heard of. It's that communications and records between attorneys and clients are not to be disclosed. Clergy communicant. So this would be a parishioner or a member of a religious institution and a clergy member. Spousal testimony and marital communications are privileged, but I put a note here because this does not apply when spouses are adverse parties or when one spouse is the victim of the other. So this privilege is not going to come up in a typical domestic violence case because either the spouses are adverse parties or one spouse is the victim of the other. But in other settings, there is a concept of spousal testimony or marital communications are privileged. Healing arts practitioner and patient. So other jurisdictions might call this doctor-patient privilege. This would be medical professionals. The communications with medical professionals are privileged. Mental health professionals and their clients, those communications are generally privileged. And then there's a rule that protects communications involving interpreters, which would really be to protect the interpreter from being dragged in to disclose information that would otherwise be privileged, but they were just there to facilitate the communication. So a quick note on the healing arts practitioner and patient and the mental health professional and client privilege rules. Those categories of individuals are enumerated in the statute. So although one might consider themselves a healing arts practitioner or a mental health professional, whether or not privilege applies to that person depends on whether they actually are a healing arts practitioner as the rule defines it, or a mental health professional as the rule defines it. So these are not subjective definitions. They are clear definitions that exist in the statute. And we're going to get into, I'm going to actually show what those mental health professional categories are in a few slides. But just in general, remember that when we see the words like healing arts practitioner, that's a defined term. So it does have meaning that is included in the statute. So when we think about how these concepts relate, this is one way of sort of visualizing how these concepts relate. So we have information that we receive in our daily life, and there may be a general expectation of privacy, right? So a friend may tell us a secret, someone may tell us something sensitive, we may overhear something sensitive, and maybe we have a societal expectation of privacy in those communications. A smaller subset of those communications actually include a duty of confidentiality. So this would be communications where a professional has a duty of confidentiality to their client. And then an even smaller subset of those communications, which are confidential, are actually protected by rules of privilege, or they're considered privileged. The smallest category of communications are those that are protected from compelled disclosure in court. So you'll notice that there is this gap. There are communications that are confidential but may not be protected from disclosure in court. And really the purpose of this training for advocates is to explore that gray area and figure out really what do you do when you have a duty of confidentiality, but you may not be considered, your conversations may not be considered privileged. We created this second way of thinking about how they relate, because I think that earlier graphic is helpful, but I think this is a little more accurate. So it's not that they're completely overlapping concentric circles, it's that they are more like a Venn diagram. So we have some conversations where there's confidentiality, and some conversations where there's privilege, and some where there's both, right? So when we look at the middle, conversations with lawyers, doctors, and mental health professionals, those communications are both confidential and privileged. And what that means is when we think about confidentiality, that is a rule or a duty that's created by laws. It's either created by state or federal laws. Lawyers, doctors, and mental health professionals are regulated by their professional regulating agencies. So they have state regulations that create a duty of confidentiality. We also have court rules that provide a privilege for those conversations. So those things really fall in the middle. When we go over to the confidentiality piece, most advocates are going to fall within that area. And that is that we have a state law that creates an obligation for advocates to keep those communications private. We also have federal law that creates obligations for for recipients of federal funding. So an example would be VAWA. The Violence Against Women Act has obligations that are created for programs that receive federal funding. So there's several sources of law that create a duty of confidentiality. Hospitals, I put that here because it's one way of thinking about this issue. There's a federal law, HIPAA, or several federal laws that create obligations for hospitals, but there's no such thing as hospital patient privilege, right? There's a doctor patient privilege or a nurse practitioner patient privilege, which we call healing arts practitioner in Virginia. But hospitals themselves as entities don't have privilege. They have a duty created by federal law and state law to protect the information of their patients. On the other side, you can have communications that are protected by privilege rules, but that aren't governed by state or federal law that creates a duty of obligation. So an example would be clergy communicant privilege. Those communications are privileged, but there's no laws that say that church institutions or clergy members have to keep secrets for their members or for people who communicate with clergy. Religious institutions may have those internal rules themselves, but those don't come. There's no duty of confidentiality that's created by law for religious institutions. Same is true for marital communications. There's no law that says you have to keep the secrets of your spouse, but there is a rule of privilege that in some instances can protect you from having to testify against your spouse. So it's helpful to think about these things as confidentiality and privilege are related principles, but they're not exactly the same thing. And really, most advocates are going to fall into that yellow space where they have a duty of confidentiality, but they may not necessarily have a rule of privilege that would protect them from having to disclose that information. So when we look at the mental health professional privilege, I'm highlighting this one because I think it's where some advocates may actually fall. This applies, like I said, to certain defined individuals, and this is defined in our statute and our court rules. Mental health professional is generally defined to include licensed professional counselors, licensed clinical social workers, licensed psychologists, licensed marriage and family therapists. The key being generally the mental health professional privilege applies to licensed individuals. So once again, even though somebody may consider themselves to be working in the mental health professional field or responsible for mental health, it's not necessarily the case that they would be considered privileged unless they fell into one of these categories. So when we go back to confidentiality and who does it belong to, we ask the question, how is confidentiality waived? And the answer is pretty simple, a waiver. Clients have the option and the privilege or right to waive confidentiality. They would sign a waiver that meets VAWA requirements. So these are the requirements for an appropriate waiver: written, informed, time limited, signed by the victim, and a limited scope. So, and it must be accompanied by a discussion with the victim so that they are making an informed choice about what they're waiving. And again, a specified duration. How is privilege waived? So this is a little different. Privilege can be waived in two ways. It can be waived deliberately or inadvertently. So when we think about a deliberate waiver of privilege, the protected person can waive privilege by signing a waiver or a partial waiver. So if a survivor has a conversation with their doctor and in litigation, they want that doctor to testify, they can waive privilege. They can say, it's okay with me. I want my doctor to testify. Therefore, this communication that would otherwise be privileged, I'm making the choice to waive it. Waiver can also happen inadvertently. So people can accidentally waive privilege. So the presence of a third party in otherwise privileged conversations can sometimes be deemed to be a waiver of privilege. So this can happen with, if a conversation that it would be privileged, so let's say an attorney-client conversation, if the client or the attorney allows the presence of a third party, that can sometimes be deemed by a court to have been a constructive waiver of privilege. So I say that because sometimes attorneys don't want advocates to participate in conversations with the client and the attorney. And that can be really frustrating for advocates. I was an advocate for many years before I went to law school, and I understand that frustration. But it's important to understand that part of the reasoning behind that is very likely because the attorney is concerned about an inadvertent waiver of privilege. When privilege is waived, that means that conversation is no longer protected against disclosure, so that any person in that conversation can be subpoenaed to testify about what happened during that conversation or what was said. At least in theory, that's what that can mean. So it's a pretty serious thing. Clients can inadvertently waive privilege, and in our age of email communication, this happens frequently when clients forward privileged communication, so emails to a non-privileged party. In doing so, they can inadvertently waive privilege. So for advocates working with clients, if they start to forward you emails from their attorney, I would really encourage you to tell them to stop doing that. Number one, the attorney may not know that they're doing that, but the client may not understand the consequences of doing that can be a waiver of privilege. So really encourage your client, educate your clients around what that can mean for them and why they should probably not just hit the forward button on privileged communication. So quickly, who is a mandated reporter in Virginia? And we're going to discuss this because it does intersect with confidentiality and privilege. For folks who are mandated reporters, sometimes these principles really may conflict with each other. You may have one duty to protect confidential information and a competing duty to report suspected abuse. So in Virginia, it's important to understand who actually is a mandated reporter. It is an enumerated list of individuals. Now, I'm going to put this code section here, and there'll be a handout included with the materials. I would encourage you to read this list. It's a long list of individuals, but in general, advocates are probably not going to be included on that list. There's a couple areas where that could happen. For instance, if an advocate participates in a training by the Department of Social Services on mandated reporter, then that can make that advocate a mandated reporter. But in general, an advocate at a sexual or domestic violence agency is probably not a mandated reporter in Virginia. Again, I just put the code section here because that list might change, but it's important to just go to that list directly, go to that code section directly, and ask yourself, are you actually a mandated reporter? And if you have questions about this, I'll put my contact information at the end, and you can reach out and we can definitely talk about it. It's really important to understand, though, if you are or are not a mandated reporter, because you could run into a situation where your communications with a client are confidential and or privileged, and you're a mandated reporter. So this is that competing duty that I mentioned before. You might have two competing duties, right? You're required by state and federal law to protect this information, but you may be required to report this information. So both Virginia law and the VAWA confidentiality provision allow for the release of information if the person disclosing the information is a mandated reporter. That's why it's really important to understand if you are or are not. And if an advocate does disclose confidential information for the purpose of mandated reporting, you must make reasonable attempts to provide notice to the victim affected by the disclosure and take steps necessary to protect the privacy and safety of all persons affected by that release of information. On the flip side, what if you break confidentiality to report child abuse, but you're not actually a mandated reporter? But you think you are, but you're not. Well, without a release from the client, you may be inadvertently violating the law. So you may be violating the VAWA confidentiality provision by doing that, and you may be jeopardizing the funding that your organization receives. The VAWA confidentiality provision only allows this without the client's consent if the person is covered by a mandatory child abuse reporting law. So again, I go back to that list. It's really important to know what that list says and know if you are or are not a mandatory reporter or mandated reporter. And if you have questions about that, it's important to talk to your executive director or reach out to get technical assistance to find out if you are. So the other thing that we are going to talk about is really when you receive a hostile request for confidential information. And when I say hostile request, I mean you get subpoenaed by the abuser's attorney, a defense attorney, basically somebody who wants you to testify, but your client does not want you to testify. This is really a nightmare situation for advocates, and it does happen, it can happen, and it's important to be prepared for it. So there's two types of subpoenas. There's subpoenas for records and subpoenas to testify. It's important to, if you do receive one of these, a subpoena, it's important to understand the first question. Well, we'll get into the first thing you should do is tell your executive director. But one of the first questions you should be asking is, where is this coming from? Is this coming from an opposing or an unfriendly or hostile attorney, meaning not someone who has your client's best interests in mind, or is this actually coming from your client's attorney? I mentioned an example earlier where a client may actually want you to testify. They may actually be on board with you testifying. And again, clients, the protected person, always has the option to waive confidentiality or even waive privilege if it serves their interest. However, it's important to understand, is this an unfriendly subpoena or a friendly subpoena? Basically, does the client want me to cooperate with this or not? So it's important to immediately notify the survivor and let them know that this is happening and understand what their position is on the subject. There's been situations in the past where advocates have gotten subpoenas, panicked and started to think about, how am I going to resist this, without really actually realizing this is coming from the survivor's attorney. This is actually a friendly request, not a hostile request. It's still important to prepare and be ready for this, but one of the most important questions is, who's actually subpoenaing you and why? And like I said, there can either be a subpoena for records, which is called a subpoena ducis tecum, or a subpoena to testify. And this would be actually where an advocate is being compelled to go on the stand and potentially testify. So here's some do's and don'ts. Do tell your executive director immediately if any program or advocate in Virginia receiving a subpoena has major implications for the program as a whole. So it's important to immediately escalate this to the executive director. You should also tell the survivor immediately, or the client affected by the subpoena. The executive director should tell the board, and the board should help the executive director retain outside counsel. Outside counsel can file a motion to quash, which would be an attempt to quash a subpoena. And the subpoenaed individual should check in with their applicable licensing agency. If you are licensed, you need to understand what your individual requirements are in this event, right? So getting a subpoena is not fun, but it's important to respond to it immediately. Some things not to do: don't ignore it. If you just refuse to show up, you can be held in contempt of court. Don't panic. Don't immediately just hand everything over. There's a timeline created in subpoenas, and the purpose of that is really to give the person or entity being subpoenaed a chance to respond and resist it, like I said, with a motion to quash or something else. Don't assume that on the day of court you can just claim privilege or claim confidentiality or conflate those two things, because a judge is going to be very, very clear about what the difference between confidentiality and privilege is. And a judge is also going to be pretty clear on whether or not your communications are privileged. So advocates can make the mistake of coming to court and being confused about the difference between those things and attempting to refuse to testify based on confidentiality, when what they really mean is privilege. And they're disappointed to find out that that argument doesn't work on the day of court. Do not destroy records. There's a principle called spoliation, which just means that when records are subpoenaed, generally, if a party starts destroying records in response to a subpoena, or once they're on notice that litigation has started, that can have really harmful effects for the case. It can have actually the opposite effect of what you're hoping for. Courts are allowed to draw negative inferences against parties when there's evidence that they've been destroying records. So don't destroy records. And like I said, don't fail to notify your licensing agency if you happen to be licensed. It's important to be clear about what implications this has for your program, for the survivor, and for you as an individual. So because we're aware that there is a risk that these things can always be subpoenaed, we do recommend some best practices for advocates. We are going to do more trainings on this, and we'll get into more depth. Again, this is really just a broad overview and meant to be more of a primer. It's a way to get the conversation started. But in general, we recommend very, very limited records. Record keeping is necessary because we have to keep records for funders and for effective case management. But to the extent you can keep those notes extremely limited and limited to the bare minimum, that's what we recommend, because we want those records to be as useless as possible for any potential hostile attorney who may want to get their hands on them. Records should contain only firsthand knowledge. Do not include any hearsay. And that includes things that your client is telling you that you believe to be true, but you don't have firsthand knowledge of it being true. Again, just because you're not keeping records of it doesn't mean you don't believe your client. It just means that you're not going to put hearsay in your records. Don't include quotes from the victim. Don't record your personal opinions or observations. Don't include extraneous documents from other sources. And that can happen when clients ask you to hold on to things for them and you put it in their record, which I think many advocates do to be helpful, but don't hold on to those things and don't keep them in the record. So always ask, what would happen if anything you wrote were disclosed to the most dangerous person possible, the abuser or their attorney? So as you're keeping records, think through what is the worst way this can be interpreted, because that is a potential. Again, our goal really is to keep clients safe, keep their information confidential. And part of doing that is just by keeping some of these best practices for record keeping. I do want to say that if an advocate listening to this has received a subpoena, I would really encourage you to reach out to the Action Alliance. Reach out to your executive director, of course, but the Action Alliance is always here for technical assistance regarding this. We can have a much more in-depth conversation about how to prepare for any sort of subpoena, how to respond to it, and worst case, if an advocate is subpoenaed to testify, I work with advocates throughout the state on how to prepare for that and how to do that effectively. So my contact information is here. You can always reach out to me for technical assistance questions. That is something that's always available. But I also want to open up, we've got a live audience with us during this recording. So I want to open it up now to any questions that folks may have.
Hey, Caitlin. Laurel here. I have two questions. So earlier when you were talking about accidentally waiving your right to privilege, you mentioned that a survivor might be forwarding emails from their attorney to their advocate, and that would be a waiver of their privilege, a waiver of the privilege. What if a survivor just wanted to tell their advocate what their attorney told them? Maybe they were trying to get a better understanding. They have like a legal advocate and their attorney maybe emailed them something that they wanted clarification on, but they just verbally told their advocate rather than emailing it to them.
Yeah, so that's a great question, Laurel. That's a lot safer, because when we think about things that an opposing or hostile attorney can get their hands on, it's generally things that you've put in writing or that somebody has put in writing. So emails, notes, things like that. Verbal communications are a lot harder to track down. And so I do think that certainly survivors have conversations with their attorneys and they want to process that with their advocate. That's a relatively safe conversation to have, because no one's going to find out about it, right? So the advocate is not going to put that in their notes. There isn't going to be a paper trail or an email thread where that happened. The concern about email is, a subpoena might say, print off every single communication you've had with this client. And that might include an email that your client that the survivor sent you, which then if the other side gets to it says, oh, wait a second, I see that there's a privilege waiver here. Perfect, right? So when we think about protecting communications, anything that's not in writing or discoverable is a lot less discoverable, okay? And when I say discoverable, I mean the general process of what's called discovery in litigation. So, like I said, I think that verbal conversation is a lot safer than one that can be found in writing. Did that make sense?
Yes, it did. Thank you so much. I also have a second question. When you were talking about keeping particularly light records so that not a lot can be pulled, I was just thinking about how advocates, you're right, we don't want folks necessarily putting in their personal opinions, but we do often take notes and we say like, this is something that was noteworthy. They said they were scared about something, but they didn't explicitly say why. I feel like, I guess I was just wondering, when might there be moments where advocates can take notes for themselves to know how to do better safety planning and things like that in a place that isn't likely to get subpoenaed?
That's a good question. I mean, I'm really going to encourage not doing that. And the reason why is that notes that we take about our impression. Of course, as an advocate, we view our client in the best light possible. We believe our client, we sympathize or empathize with our clients. So we may be taking notes like she was scared or she was, reacting this way. And from our perspective, we're recording positive impressions, but taken in another light or skewed by another party, those same things that we think are favorable can be really quickly turned on their head. So I think that I would, again, just really encourage not doing that. I think, again, I wouldn't record things like she said this or she felt this. Let's say, from a safety planning perspective, you make a note, firearms present in the home. I think that's the kind of factual note taking that's relatively safe to take. But I would not record things like your impressions of their mental state or things that the client said, if that makes sense, as much as possible.
Okay, thank you.
Thank you for the question, Laura.
Hey, Laurel, I have a question as well. This is Hannah.
Hey.
What if these laws change? Like, what happens then?
So great question. So this is a great question because every year the General Assembly meets, and at any point these laws could change. The federal laws are subject to change, but probably are a little more stable. So the ones that I would say are important to keep an eye on, especially, would be that mandated reporting list, which could change. Any statutes or court rules can be changed on a yearly basis. So it's a good question. I included the statutory references here. And what I would encourage anyone to do as they're listening to this recording or they're looking at the handout materials is actually go to the direct source. Go look at the Virginia Code online. I know that when I was an advocate, I was really scared. I found I lived in a different state, but I found the state code to be really overwhelming and intimidating. But if you just go to those code sections and start to bookmark those and start to familiarize yourself with, okay, this is where I can find this information, you can go back to that and just monitor that for any changes. And it's important to just be aware of what those changes could, monitor those things as they change. Also, again, if you're confused or have any need for technical assistance, my email is right there, or someone at the Action Alliance could help you track down what the most recent law is. But that's a great question, Hannah. Thank you.
Thanks.
Caitlin, I also have a question, and I'm sorry if you covered it earlier, but I've heard that sometimes advocates can redact information from records before they share them. Is that something that can be done to help protect confidentiality?
Yeah, it's certainly something that they can try to do, but a judge may reject that and say, like if a hostile attorney were to receive a redacted record, there's always a possibility that they would go to the judge and say, no, this is unacceptable, compel disclosure, right? So I wouldn't, certainly in the, upon receipt of a subpoena, my advice is to fight as hard as you can, right? Redact, make objections, file a motion to quash, do all these things. I think it's important to fight, but remember what the vulnerability is that ultimately those unredacted records may be discoverable. So that's why in the first instance, keeping those light notes is really important, because redaction, I think that's a great strategy, Tamara, but it may not be foolproof, especially if those records, like I said, are probably not privileged. And so redacting may be a tactic that the judge ultimately rejects. So again, thinking about that vulnerability, we want the unredacted version, the worst case scenario, you have to hand everything over. We want that to be as light as possible.
Thank you. That was helpful.
Yeah, no, that's a good question.
This is Carmen. Thank you, Kaylin, for a very good presentation. And my question will be, how can we get copies of this presentation? and when they will be available for us?
Thank you, Carmen, for asking that. So the copies, the slide deck that was included here is going to go out. It's going to be included with the video along with a few handouts. And so that should be available. If there's any issues with that, again, you can reach out to me and I can provide these at any time. But they are going to be provided with the recording.
Thank you.
Along with an evaluation, so that we will find helpful.
Wonderful.
Awesome. Are there any other questions? It doesn't sound like it.
Actually,
Oh,
just
okay.
kidding. One more. How do you suggest advocates go about building relationships with the attorneys and judges in their areas to help recognize the importance of confidentiality and things around survivors of violence?
So that's a really great question. At the Action Alliance, we really encourage coordinated community response teams and really interdisciplinary teams in communities, because these conversations are really important. It is crucial that judges and prosecutors and law enforcement and attorneys working within the system understand that the relationship of advocates and survivors is critical to victim safety. And the promise or the security of that information or that relationship will be protected and that information will be confidential is absolutely critical to victim safety and the healing that survivors must go through as they're exiting dangerous relationships and situations. So Tamara, I really appreciate this question, because I do think that advocates have an important role to play in their communities in educating and advocating for survivor rights in this regard. Again, we don't have rules that grant privilege to advocates, but we do have a duty of confidentiality, and it's important that judges understand and that other players in the legal system understand that advocates are an important part of the system and that those relationships really deserve that protection. So I really encourage advocates listening to this to advocate for those protections and educate the players in your community. I do think that this primer, understanding the difference between these concepts, I hope will be helpful to advocates as they're talking with those players in their communities about this, because again, sometimes I know when I was an advocate, I found I conflated these principles a lot, but really understanding the difference between these things and where those vulnerabilities lie is important as advocates go into their communities and advocate for changes that will promote victim safety.
Thank you.
Thank you. I think that might be all of our questions. I really appreciate my studio audience today. And for anyone listening to this, please do not hesitate to reach out to me or to anyone at the Action Alliance with questions. I recognize that this was a really broad brushstrokes overview of some pretty complex principles. And as advocates are facing individual situations in their work, there can be much more detailed questions that they have. But I hope that this primer was helpful in at least getting that conversation started. So again, reach out if you need me. Thanks so much.